Welcome to Legal Guidelines Prep for Florida Law Enforcement Officers. This is Deputy Z, and today we'll be covering civil rights violations under federal law, with regards to Florida statutes on police liability under federal law, civil liability, conspiracy to interfere with civil rights, and criminal liability. So let's start with police liability under federal law. Whenever any individual interferes with another's rights, there is a possibility of civil or criminal sanctions. The federal law in this area has been termed the Civil Rights Acts, but it actually divided into two areas, civil and criminal, each with its own unique definitions. And now for civil liability. Section 1983 of Title 42 U.S. Code. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other properly proceeding for redress. The only elements which need to be present in order to establish a claim for damages under the Civil Rights Act are that the conduct complained of was engaged in under color of state law, and that such conduct subjected the plaintiff to the deprivation of rights, privileges, or immunities secured by the Constitution of the United States. See Marshall v. Sawyer. If you act in your official capacity, you are acting under color of state or local law, and if your conduct results in the deprivation of any constitutionally guaranteed rights, you could be liable not only for actual damages, but for punitive damages if the element of malice is shown. Not only are improper acts committed under the color of law actionable, but also any act pursuant to local custom or usage that deprives a person of their federal constitutional rights. You are not liable for those acts which are purely ministerial in nature, such as serving of warrants, search or arrest, pursuant to a court order unless you exceeded your authority. If you arrest without probable cause, you could be liable. However, you will not be held liable for enforcing any law that is later declared unconstitutional. Even if the complainant was convicted in state court in connection with a transgression, for example, resisting arrest, burglary, or any crime incidental, this is not an available defense which shields you from liability. Defenses available are a matter of federal law and policy. States cannot create defenses to the Federal Civil Rights Act. Good faith and probable cause are defenses under a charge of false arrest brought under Section 1983 and prevalent tort law. The act complained of need not have been willfully committed for liability to attach, nor is it necessary to prove specific intent to deprive the plaintiff of a federal right. All cases of action arising out of Section 1983 must be for those acts committed by the officer under color of law, regulation, custom, or usage. And now for conspiracy to interfere with civil rights, depriving persons of rights or privileges. Section 1985 of Title 42 U.S.C. 3. If two or more persons in any state or territory conspire for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protection of the laws or of equal privileges and immunities under the laws, in any case of conspiracy set forth in this section, if one or more persons engaged therein do, or cause to be done, any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. This section deals with conspiracies to interfere with constitutionally guaranteed rights. It differs from 1983 in that it sanctions conspiracies of either public officials or private persons. Conspiracy necessarily involves two or more persons, and a successful completion of the conspiracy is not essential, but rather an overt act in furtherance of the conspiracy injuring a person or depriving him or her of property or the exercise of any rights or privileges of a citizen of the United States is compensable. There must also be an intentional or purposeful design to deprive the citizen of any of his or her secured rights. And now for criminal liability. Section 242 of Title 18 of the USC Section 242 of Title 18 makes it a crime for a person acting under color of law to willfully deprive a person of a right or privilege guaranteed under the Constitution or any federal law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in a state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race, than are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year, or both, and if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this subsection, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death. Federal cases of action under Section 1983 are only civil in nature, and the remedies include money damages, nominal, compensatory, and punitive, injunction relief, and declaratory judgments. Federal violations under Section 242 have with criminal sanctions for some of these same types of illegal activities, and the courts read this section in conjunction with civil sanctions. There are two ways you can be liable when your actions deprive a person of a right, privilege, or immunity protected by the Constitution of laws of the United States. 1, if your actions are willful, for example, you intentionally deprive somebody of his rights, or 2, by willfully subjecting any person to a different punishment or penalty because such person is an alien, or because of their race or color, other than is prescribed for the punishment of citizens. A violation of Section 242 may subject the offender to a sentence of death, imprisonment, a fine, or both imprisonment and a fine. Examples of actionable deprivations under 1 above: A, arrests made without probable cause or an arrest warrant. B, illegal search and seizure. C, unlawful assault or battery. And D, wrongful homicides. In all the above actions, there must be an element of willfulness on the part of the officer, but the fact that the defendant officer may not have been thinking in constitutional terms is not material where his or her aim was not to enforce local law, but to deprive a citizen of a right, and that right was protected by the Constitution. Section 241 pertains to police officers acting under the color of law, as well as to private citizens, but it differs from Section 242 in two major respects. First, Section 241 is applicable only to conspiracy involving 2 or more persons. Secondly, Section 241 pertains only to citizens of the United States, whereas Section 242 pertains to any person within federal jurisdiction. A violation of Section 241 is a felony which may subject the offender to a sentence of death, imprisonment, a fine, or both imprisonment and a fine. The county may assume responsibility for compensatory damages, but no local government would be authorized to pay any part of a judgment or claim which is punitive. And now, criminal liability special exceptions. The statutory description of each crime lists the elements of the crime, the acts and mental state required for conviction. No violation occurs unless the defendant has acted in a manner and with the mental state that constitutes all the enumerated elements. A majority of the felonies listed in the Florida State Statutes require criminal intent as one of the elements. When the necessary intent is lacking, there is no violation. For example, the statutory crime of burglary is not committed unless the person who enters has the intent to commit some crime inside the premises. However, some felonies and majority of misdemeanors do not have intent as an element. Merely doing the stated act or series of acts constitute a violation of the law. In the above example, the crime of burglary would not have been committed absent intent. However, without legal authority, the crime of trespass occurred. There are a number of special legal exceptions, exemptions, and defenses available in specific cases. One example is a legally issued court order directing a law enforcement officer to search a designated premise. Without permission on the authority of a judge, the entry of the premises without the permission of the owner will constitute criminal trespass. The court order, therefore, is a legal exception in this example. The Controlled Substance Act is another special exception to the rule. There is a statutory provision exempting law enforcement officers from prosecution for possession of a controlled substance when the possession is part of a supervised investigation. Therefore, any person or law enforcement officer who commits a prohibited act without a legal exception exemption, or defense is subject to criminal prosecution. If, in the course of an ongoing investigation, department members feel that activities that constitute criminal violations are likely to occur, they should check with their supervisors and the Police Legal Bureau for advice. With probable cause, as a general rule, once probable cause to arrest is established, a law enforcement officer cannot be held liable for false arrest under state laws or deprivation of civil rights under this statute. See Hunter v. Clardy. Any collateral bad motive or intent on the part of the arresting officer is then immaterial. And here are some cases brought under Title 42, Chapter 21, Subchapter 1 of 1983 of the U.S. Code. So here are some examples brought to trial under these. The first one, failure to advise grounds for arrest and detention. 2, detaining the person arrested for too long a period. 3, assaulting the person arrested. 4, committing a battery upon the person arrested. 5, entrapping the person arrested. 6, performing an illegal search or seizure upon the person or property of the arrestee. 7, failure to provide the person arrested with medical attention. 8, placement in an unfavorable or suggestive lineup. 9, failure to protect victims' anonymity or safety. 10, use of unreasonable force during arrest or detention. And 11, verbal abuse during arrest or detention. And that concludes civil action for deprivation of rights and the Civil Rights Act. Deputy Z signing off. As always, make sure to check your agency policies and procedures.